Right, welcome back to the 48th episode of the podcast that we call The Unknown. My name is Michael Volpe. I report from Chicago, Illinois, which is in Cook County, Illinois, and I write at michaelvolpe.substack.com. And my broadcast partner, as always, Richard Luthmann, somewhere around Fort Myers, Florida, in Lee County, named after, of course, Robert Edward Lee. And you write at luthmann.substack.com. That's luthmann.substack.com. All right. And I think there was a bit less news in the week this week. However, I woke up to the news that we've got another trade deal. And this one's with Japan. That's relatively important. I'm not exactly following the details. We're still charging them uh, an extra. Hold on one second. Uh, we're still charging them some tariffs. They're going to import more stuff. That's basically what I was getting. Uh, and I, I don't know the details, but um, it's it's a step in the right direction. Japan is a pretty significant trading partner. So here, in return, in social media posts, President Trump declared they have reached a massive trade deal with Japan. Japan has agreed to open its market to more imports of American cars and rice, as well as invest 500 billion in the United States. This part is pretty specific. The other part isn't, and then we're going to lower tariffs from 25% to 15%. That actually sounds like a pretty good deal, but I don't have that many specifics here. But I like it. Uh, I'm going to move him up to a C plus in terms of trade with this trade
Come on.
deal. And but if he keeps him rolling in, he's going to get into the B's. And if he gets one with China, then we got an A. But right now, C plus. I'm liking this deal.
So you talked about, I think last week we talked about the Indonesia deal, and you just
Mhm.
didn't understand why that was so important. I hope now that you see why it's so important because the Indonesia deal led directly to the Japan deal. And so it's kind of like your Dutch tulip auction. For anybody who's taking an economics class, they
Mhm.
talk about the Dutch tulip auction, and everybody wants to be there first, and everybody wants to be able to get that. But when they see another buy, there's a reaction. When one buyer does something, the other buyers are affected. This is kind of what it is. Everybody wants the seat at the table, and so when somebody's perceived to get first and better terms, then there's that impetus. And I think Japan got pretty good terms here. The United States got pretty good terms here. This is a win-win for both countries. Remember, Japan is one of our major allies in the world. We should be doing good trade deals with our allies.
Mhm.
So I think this is a very positive benefit, but it also cements our commitment to that part of the world. And like you said, the eye is always on the prize with Trump, and that's China. China
Right.
is the dragon. China is
Right.
the major adversary of the United States along with Russia. And
Mhm.
Trump's not taking his eye off the ball here. That's what this whole thing is. It's doubling down on our commitment to Asia.
Right. It's going to increase the price of Japanese cars, which are pretty popular in the US, even with the lowered tariffs. But that said, $500 billion investment into the US sounds like it's a pretty big deal. So I like that. As I said, I'm moving him up to a C plus on trade. And if he keeps going like this, he's going to get to an A soon. But he still hasn't made a deal with EU and China, and those are two big ones. England and Japan. That's how it's a C plus. He's like halfway there. I'm being fair. I'm not grading like especially tough. Uh, if he gets a deal with the EU, that's a pretty big deal. That then he's pretty much all the way there. As I said, he may change the perception for centuries of the way the U.S. views trade and seeing tariffs as a tool, which was never, not never, but for many decades was not seen as a tool. And I felt that's why I voted for him. Not the only reason, one of the main reasons in 2016, because he had a really good rap on it in terms of how he saw the trade vision, but it didn't materialize. He never really got many trade deals. But this time around, he's starting to get them. So uh, he's halfway towards getting what he wanted accomplished, which is England, Japan, EU, China. England and Japan have deals, two more to go.
you have to understand how diplomatic staff works and State Department. You got a lot of these careerists. So when Trump wanted to do changes in 2016, 2017 when he got into office, you got to understand there's the culture there that you have these people that are doing things the same way for a generation, and so that stopped kind of for 4 years the hiring of these certain types. It kind of cleaned it out a little bit. A lot of people took packages. Then you had 4 years of Biden to put other people in. But now a lot of them retired before Trump or left to packages before Trump even came in. And since Trump has been in, a lot of people in this diplomatic corps have left, gone to academia and done other things. They don't want to be under Trump. He has the people that he wants that believe in his vision. He has true believers at this point in the trade deal vision, in a tariff structure. And that's why there's a difference right now.
Well, he had Biden for 4 years in the middle, so I'm not sure how he could put all those people in place. But be that as it may, his history is not going to get in those kinds of details. He's got another chance. If he puts a bunch of trade deals together, no one in 50 years is going to, yeah, but what about his first term? That's not going to matter. He has an opportunity to completely reset, which is transformative in just remarkable ways, the way we view trade for a very long time. He has a chance to reset the way we view illegal immigration as well. He has a chance to reset the way we view the budget, but he hasn't done that yet. Now, onto a story that won't go away entirely due to the statements before and during the administration of Trump and many of his underlings. Jeffrey Epstein, now the Deputy Attorney General, his name is Todd Blanche, wants to meet with, I don't know what you'd call Ghislaine to Epstein, his madam. She's his madam. She was recruiting and helping to.
I don't think so, Maya. I think associate's the proper word here, because we don't.
Well,
we
she
never
was convicted of sex trafficking. So
I know this, but are you going to say a madam? I don't know exactly that's it, but it's an associate. That's a criminal associate. That's the proper term.
Right.
What was Sam Pizzano to John Gotti? A criminal associate.
Right. So I think this guy is one of the top people in the AG's office. Wants to meet with her. They're treating this case not, there's a lot of high profile defense. Are they meeting with Diddy? No. Why aren't they meeting with Diddy? Are they meeting with any other high profile convicted felons? They're treating this like it's different. They're trying to show their base that they're serious, and serious about what? The people who believe this, they want to believe that what was happening was an elite pedophile ring, that what Epstein was doing was organizing kind of orgies that they thought that Diddy was organizing, that I don't think he was organizing, where he was bringing in through force, fraud, or coercion, a bunch of women, many of them underage, and going to a private island with a bunch of important people like Bill Clinton and maybe Bill Gates and others. And they were all passing around these women who were being trafficked. And I don't think that actually happened. He was doing it for himself, but I don't think he was passing around women to his friends. And as a result, you may be chasing at windmills. So what are you meeting with this lady for? If they give her a pardon or anything that gets her out of jail early, that's a really big problem.
I think that you're not going to convince me until you show me evidence to the contrary, that the entire Epstein Island was a deep state psyop, was a deep state type situation. I think it was a CIA off-book operation. I think that the easiest explanation is that Epstein was working for an intelligence service. I don't think it was Israel. I think it was the CIA, but it was an off-book deep state type situation. I think that's
what about my point? Is it appropriate for the Deputy Attorney General to be meeting with a convicted felon?
Yes, if Ghislaine Maxwell was working for the United States government. And that's
right.
the problem.
Well, if it was a fifth,
that's the elephant in the room. What fixed this fact pattern better than she was really working for under the
wait. Stop right there. Is President Trump in a position to know any of the speculation that you are talking about? If she was working for me.
He knows about Area 51.
All right, so
Area 51. He said that he knows the truth about Area 51.
Your speculation is that he knows that she's a really big deal in the intelligence world, and so it's appropriate for her to meet.
That's not right. That's not right. My speculation is this: based on the evidence, that the institutional integrity of the CIA is at risk because of what may have been done by the deep state operatives working off book. And it's Ghislaine Maxwell and Epstein were basically de facto CIA book operatives run by like a John Brennan off book campaign. Then that could be detrimental to the CIA and national security. Trump is one who wants to protect the country from disgrace. So that's why this is happening.
I would say that if number one, if it was a fifth, we'd all be drunk. Number two, what if what you're saying is completely wrong and none of that is accurate? And in that
imagine
case,
if it's all true, Mike.
I
It's
think
the fact pattern. Everything I think is true. That it's the fact pattern.
Blah blah blah. All right. So we have another news story. Now this is a two-part news story. Part of it is came from Bill Malugan, I think I got it right, and others reported over the weekend or maybe on Friday that ICE picked up a Mexican illegal immigrant. His name is Jose Luis Mendoza Gonzalez. He was accused, he hasn't gone through the entire criminal process, but of decapitating a missing Illinois woman and storing her body in a storage container filled with bleach. But the key was he faced one court appearance, and Lake County Judge, here's her name, Randy Bruno, released him from custody. Part of the reason she released him is a 2021 Lake County, Illinois, I should say, Illinois law, which made it much easier for those charged with a crime to be released, including the abolition of cash bail and a whole bunch of other things that, in effect, made it gave all kinds of incentives for judges to lower bail or reduce bail to release people. And this was one of them. And ICE picked this guy up. And the other part of the story is in 2024, I covered a case with a guy named Sebastian George. And I think it was November or December, I called you because Sebastian's, I think she was 16 at the time, daughter threatened to kill herself. I didn't know what to do in an email to me. And the reason she threatened to kill herself is because Judge Bruno gave him sole custody and ignoring the evidence that he was molesting her in favor of a bogus report from a hack named Dr. David Finn, who claimed that the allegations of child molestations were a manifestation of her mother, Susama George, her Munchausen syndrome by proxy. He did a novel spin on Munchausen, in this case saying that through her Munchausen, she has convinced her daughter that she was molested when she really wasn't. It's total and complete garbage, and the girl wouldn't be suicidal months after not seeing her mom if any of that was true. This judge seems to be a bad character. Am I wrong?
I think that you're 100% right, Michael. This is, first and foremost, it looks like we have a situation of poor judgment, if anything, right? This is a poor judgment by a judge in releasing.
That sounds like the fatal flaw if you have poor judgment as a judge.
Well, that's right. I think that we have instances here across the board, right? Just releasing this person who should never have been released, right? And making a determination about the safety of the community, right? That's a very poor decision. How can she be expected to make about its situation about safety of children?
Right. And look, the Safety Act that helped push this along is extremely controversial and probably wrong-headed. But the Safety Act did not force her to release this guy. It maybe encouraged her. And of course, in the act, it has carve-outs for dangerous people. This guy's accused, not convicted, and that's what she's relying on. Well, he's only accused. We're going to treat him as innocent until proven guilty of decapitating her, putting her in a storage closet. I think what he said is that she died accidentally, and he freaked out, in effect, that he did do the storing and all of that, but he didn't kill her, which may or may not be true. But anyway, ICE picked him up, and then that turned into huge news. The other one isn't that huge news, though. It did get picked up by social media, what I broke in 2024. Now, let's move on to the next bit of current events. Are you going to be in the slammer soon? What the hell is going on? Why are you threatening DAs in New York? Aren't there enough prosecutors in Florida to threaten? Why are you going after poor Mr. McMahon? He's such a swell guy. I don't know why you'd go after him.
So The situation is this, okay? This man has a bloodlust for me. I don't know what it is. I want to live in peace down here as a journalist, and you know the key, Mike, is that they tell you write about what you know. So I write
Hmm.
about what I know. I started a career as a journalist. You've seen it since 2021. I've been a journalist. I worked with Frank Parlato. I'm working, with you. I work with others in the
Hmm.
journalism field. We've covered family courts, so I understand courts. I understand legislation. I was the law chair of the New York State Reform Party. I know how things work with politics, with judges, all that stuff.
Before we get to that, and you've written a lot about McMahon, and generally you
A
are allowed
public
to write about
figure,
him.
a political figure, an elected
Right,
official,
an elected
Michael
official,
E. McMahon. Yes.
but you part of your conviction involved the same Mr. McMahon. So as part of the release, you got a protective, or he got a protective order against you. So first of all, to your understanding, what did the protective order not allow you to do?
I've never been served with the protective order. Any purported service of the protective order was invalid. It never received it. Even if they claim that there was a return, I never signed for it. That is the big thing right now. I was never present in the court in New York where they gave me a protective order. They told me there was a protective order. The judge usually says from the bench, you have to stay away from this person. You can't contact them. You can't email them. You can't do this. You can't do that. You can't do the other thing. This, mind you, was years ago. Okay, based on
Mhm.
conduct from 2015. Okay, years
Right.
ago. Through contact 20, I did the plea invalidly under New York law remotely. So the case itself that the protective order is based on is a nullity. It's a bogus case. It's a hoax.
Mhm.
Okay, the
Right.
case was based on Facebook and free speech, and it was never taken correctly. The plea. I should go back right now and be able to fight this whole thing. It's a hoax.
All
They
right.
can
Now
do it. It violates the First Amendment, and this is lawfare. This is what Donald Trump saw from these crazy, radical, leftist,
all right. I
insane
got it.
district
Now
attorneys.
you in the article say the alleged crime journalism. So
Right.
how is your crime journalism?
They have claimed that there's a protective order that was purportedly served on me, which wasn't, and they said it says you can't do all these things.
Mhm.
How, in their fucking crystal ball, could they, in their own minds, think, okay, this protective order is valid against Richard Luthmann, who's a journalist, right?
Mhm.
The second that I became a journalist, the second that I established myself, became a member of the National Writers Union, I wrote about all sorts of different areas and became a journalist. And then I started writing about what I know, Staten Island corruption, and Camilla Hanks, who's not part of the protective order, an elected official. Well, where did the investigation take me? It took me to Michael E. McMahon, who's a public figure. I have been talking about Mike McMahon in his public figure capacity. I've never talked to him privately. I've never tried to talk to him privately. I've never reached out to him privately. I can't
Now, but
ask about his private life. I'm talking
you
about him as a public official and a Democrat Party hack figure who is corrupt to the core based on my investigation.
but you're also reaching out to him by email, aren't you?
I didn't reach out to him by email. Other
But
people have
doesn't
reached out
that
to him.
violate the protective order?
No, not his email, his public email, his public address. So I can't go to a police officer if I have a protective order against the government. You
Right.
got to understand the First Amendment says I can. I have access to the law. I have a right to petition for the redress of grievances. As a member of the press, I have a right to ask questions to elected officials. Okay.
Mhm.
Now, McMahon is a sneaky little bastard because he could have said from day one, here's the policy for Richard Luthmann as the journalist. He deals with the press office. He deals with my chief of staff. Or we don't deal with him at all. You're not going to get any answers from us, and we'll make that public. He hasn't done that. He's done this only because it's a pretext to stop a civil case that I have in Manhattan, is that I filed in November of 2023. Remember that we talked about Kathleen Waterman Marshall, the
Mhm.
judge who I talked about? It landed on her desk. Since then, it's been ping-ponging. Before that, it was Louis Knott. Nobody wants to deal with this case because Camilla Hanks, Kevin Barry Love, and Justice Ron Castorina owe me money. And their
Right.
malfeasance is the biggest issue. They lied, and I'm going to get depositions for them under oath. This has to go to discovery. I don't know how it won't. If they try to dismiss it, I'm going to take it to the appellate division. It would be the craziest case to be dismissed in history, the complaint. I
All
would
right.
get
Now
a equal
all right.
day.
I got
It's
I
out
got
of control. It's trying to short circuit my right to petition.
I got it. I got it. Now
Lawfare.
you live in Florida. This thing is this, and what is it? How do you?
It's section 215.51 of the New York Penal Law, which is it's like a domestic violence protective order. This is like a silver bullet, Mike.
So
This is where
they're saying you violated the protective order by writing about him. There's supposedly some satirical Facebook page that makes fun of him. You've obviously talked to
no,
him.
it's not
We've
that.
talked
It's not
about
just
him.
that. It's not just
Right.
that page. The page doesn't. The page itself was a Don't Rank Hanks, but he's connected to Camilla Hanks And her campaign, which I'm suing in that lawsuit in New York court, he's connected by material to supporting that campaign. He sent in Carmen Cognetta, a disgraced judge who had to leave the bench for banging his court attorney, and he had to leave. He's Carmen Cognetta is Mike McMahon's lieutenant. He's his number two. And so he doesn't do number two without going to Mike McMahon and asking him. That's what this is. He went in and he helped out Camilla Hanks knock people off the ballot. Mike McMahon's hands are in this politically. He's fair game for a journalist. He's a fair game in his political activities and his public figure status. And that's the First Amendment. And I will live and die on the First Amendment. Okay, that's the issue here, number one.
All right, now you live in Florida. This indictment or whatever it is in New York. So what happens? Can they go get you in Florida?
They're going to try. They have what I found out today, and I don't have it yet, but there's only a criminal complaint, meaning that somebody who Mike McMahon made a complaint to somebody who put it.
Now, if Mike McMahon is the DA and he's the victim at the same time, that sounds like a conflict of interest. How do they deal with that inherent conflict of interest?
There may be a special prosecutor. We're trying to find out because we get a copy of the complaint. We'll see. The problem is that the last special prosecutor, Eric Nelson, he's not the special prosecutor now, okay? And you have a new administrative judge named Ray Rodriguez, who's a political hack. And Ray Rodriguez will be the one that assigns the special prosecutors. And he's a McMahon crony. And so they probably found a hack to come in to say, oh, yeah, there's enough here to put a criminal complaint forward just to harass me. Because how this works is, Michael, this is like the Paul Boyne case. They're going to put me, because of a felony, a titular felony, into jail in Florida for a few weeks, a month, a couple of months, 6 weeks. I have to fight extradition from inside a jail cell in Florida, loss of liberty, based on the word of a bunch of hacks in New York that I violated something that I didn't violate. So I'm asking Florida Governor DeSantis to stop this. He can choose not to put the Florida.
Now, if I reach out to McMahon's office, can they claim that I'm your agent?
Maybe, Mike. They may arrest you too. They may try to arrest you.
All right. Well, that would be fun. Can we share a cell in Rikers?
I'll send everybody who wants it. It's a journalist. The number of the people or the addresses. His address is a public address. Do not contact Mike McMahon personally at his personal residence, even though it's a public record that's on the Board of Elections records. Do not go anywhere near Mike McMahon personally or his family or anybody involved with him. This is to deal with Michael McMahon as a public figure. Okay, I'm a devout Catholic. I believe that I don't want to see this man hurt. I know he does a lot, and he tries in a lot of areas, and people think he's great, but I think he's corrupt, and I think I've proven a lot about his corruption. And the fact of the matter is, I have every right to do that, and not be molested by the system, not have lawfare turned upon me for my journalism to stop New York from going red. New York is going communist. This guy is going after journalists and people trying to express themselves. I'm not the first one. Scott Lebedo and happened to too. I won't be the last. This guy's out of control. He needs to be stopped.
I think that this case is going to hinge on how much publicity you get, because if enough people understand that you are writing articles about the guy and he's trying to use some protective order from like 10 years ago, it's not 10, but about five plus years ago.
The activity was 2015, his political campaign. If you read the article, what's the problem he has with me?
People are going to be unhappy.
It's a very important point. What's the problem he has with me? I found dead people that signed his ballot access petition in true Democratic Party fashion.
Right.
Dead people.
And they're going to say
he was running for district attorney, an assistant district attorney that had retired and moved to Ohio. His signature was on the petition. He said unequivocal terms, I live in Ohio. I did not sign that document. The guy committed election fraud in 2015 when it was fashionable for Democrats to do it and get away with it. Then in 2017, I have him in shenanigans with his wife, creating a special narcotics part to try to violate the constitutional rights of the criminally accused. This man is not a good guy. Okay, everybody thinks he's a great guy. He's not a good guy from my perspective. He engages in lawfare. He weaponizes justice, and he hates when the press talks about him in a bad way. He has Brian Leyland of the Staten Island Advance. It's been his loyal hound for 3 decades. The fact of the matter is that the public needs to understand the truth. And that's all I've been doing, is exposing the truth. And I'm probably going to go to jail for this. I'm fully expecting them to throw the book at me in Staten Island unless the federal government, Pam Bondi, and the Florida government, Ron DeSantis, intervene and say, no way. We're not allowing lawfare in the state of Florida or under the government of the United States because it's against the public policy.
And you filed a notice of a lawsuit in federal court, I think, in Florida. And can you give some details about that?
I'm trying to set myself up to fight an extradition outside of jail. because usually they say you can't fight the extradition until it's happened, until you're in custody in the state. So Florida authorities, I don't think they've been noticed yet under the statute by New York. If they get noticed, they have to come pick me up. That's the law, unless the governor says no. DeSantis could say, no, this is lawfare. This is outside the public policy. Doesn't meet the statutory requirements for us to even get involved. You're on your own in this case, New York. The same thing can be said by Pam Bondi and by Ed Martin, who's the chair of the weaponization working group, who's the pardon attorney. They can come in and say to the U.S. attorney in the Eastern District, call up McMahon and say, no dice. This ain't happening with federal authorities. The U.S. Marshals aren't going to get involved in this. The federal government's not going to get involved. You're on your own. So that would mean that I would have to resolve this on my own. I would go and surrender myself, probably in New York, on time that they could process me in a matter of 4 hours. If I don't get processed in 4 hours, what McMahon's going to try to do is send the authorities after me in Florida. I fight extradition, which could take months. Then, if I lose extradition, they're going to put me on a bus, take another 4 weeks for me to go from Florida to New York in a bus. We're talking months of my life taken away from me when, if this was a normal case and you were in New York, it would take 4 hours to get done. This is lawfare. He knows how the system works. He wants to kill me. He knows I'm diabetic. He knows I have health problems. He knows that going to prison for somebody with those conditions could be very, very terrible. So the problem of the matter is that this guy is an evil, evil person. This is Stalinist, in my opinion, the type of things that he's doing.
All right. I got a second article up on the screen. Anything that people should know about from this second article?
That was the first article that came out on New York, on Florida Gulf News, talking about to Governor DeSantis about the fact that, about Governor DeSantis and the question that he has there about this. Should Florida block this? And I said that this is a national issue, and others have said this is a national issue, the same way that immigration is a national issue, in the sense that the border is along the southern border, but it's all over the country because there's an effect. If blue state and maniac, unhinged prosecutors can trample the press rights of reporters and trample the First Amendment, then it's a national issue. Any blue state prosecutor in New York or Chicago or San Francisco can turn around and take somebody in a red state that's done nothing, thousands of miles away, trump up charges, and do this. And this is what we have. I'm trying to live a peaceful life, get the hell out of Dodge, stay the hell out of New York. How the heck could I have a protective order that extends past my time for supervised release from the federal government without them telling me? They didn't tell me. They didn't notice me. They didn't explain it to me. They didn't bring me before a court and tell me what I'm supposed to do and what I'm not supposed to do. I never got any paperwork from these people. That's the problem. They allege that maybe that I didn't get any paperwork. Prove that I got the paperwork, number one, and prove you've been saying I'm crazy for 10 years. Prove that the crazy person understands what's going on here. I may have been a lawyer. They say I'm a nut. So prove that the nut knows what's going on, because I don't know what's going on here. I don't think I violated anything. I'm going to continue to do what I'm doing.
All right. Now we've got the what the hell segment. If you thought that was explosive, wait till you hear this. So even as you are trying to fight a bogus criminal indictment, or whatever you want to call it, criminal jailing, you're also being sued by a psycho named Jeremy Hales. He's got 730,000 followers. So that makes him especially dangerous. He's 730,000 roughly followers on YouTube. He's got other social media platforms, though I believe YouTube is the biggest one for him. And he figured out that he could sue people frivolously and create tons of content, and it doesn't matter how much his lawyer costs or whether he wins the case or not. He'd make so much money from the content that it wouldn't matter. And he decided to sue you, claiming that you said mean things about him and made a mean video about him. And then you went on Mean People's podcast to talk mean things about him. And so far, well, he, over the weekend, maybe, I don't know, a few days ago, he claimed that you were served with the lawsuit. Now, you were sued originally, I think in April. Now he claimed in May that you were served, and now he's saying you're served. And actually, if you were served in May, you didn't need to be served in July. So he's definitely lying, because you only need to be served once. So it's either May or July. Have you been served in May?
I was not served in May.
Were you served in July?
I was not served in July.
Now, the way
I was never served on this case, for the record.
Right now, the way these things work, the hard part is to serve someone, which means a process server or a sheriff's deputy, or sometimes just anybody has the
professional
lawsuit. They hold the paper copy of the lawsuit, and they find the defendant, and they go, Mr. Luthmann, you've been served. This is a lawsuit from Jeremy Hales. And now you know that you're being sued. So there's no question. And that's when the clock starts. The easy part is for the person who served it to fill out an affidavit saying on this date, at this time, I was at this place and I spotted Mr. Luthmann and I approached him and I handed him the lawsuit and I filed this to be correct under penalty of perjury. And then you submit that to the court. So the court knows that you were served. You know if the court has received this affidavit?
There's no affidavit of service. And if Randy Shockett, the lawyer, were to file an affidavit of service, that would be considered not only an ethical breach, but it would be a crime. It's a clear misrepresentation and a false fact. And
now, Jeremy Hale's supporters keep insisting you were served, and I keep telling them, well, then at some point we're going to see this affidavit. So far, we have not. But you decided to, I don't know, rattle some cages and send as someone who sends great emails, I'm going to say this is a top flight email. Jeremy, referring to Jeremy.
From you, Michael, that's the greatest compliment I can.
You really are pathological. You said publicly today, and hold on, let me get, today was July 20th. So when you said today, you meant on 20th on Sunday.
Podcast, it is YouTube broadcast.
Right, he does a regular Sunday broadcast. Lawsuit in the Northern District of Florida. That is a lie. I have not been served. You are a liar and an ignoramus. That means you are very, very stupid. The only man could have missed your process server as if he was the invisible man. If you purport to have served me, which you haven't, send me a copy of the affidavit of service, which he has not. Better yet, have Randy Rocket Shockett, that's his lawyer, file it on the federal court docket. Understand the first thing I will do is bring it to the FBI office for your information. Knowingly filing a false affidavit of service on a federal court docket may constitute multiple federal crimes. First, under some U.S. code, it is a felony to knowingly and willfully make a materially false statement in any matter within the jurisdiction of the judicial branch. An affidavit of service is a sworn statement submitted to the court and thus falls squarely within this provision. If the affidavit contains a false declaration under penalty of perjury pursuant to some law, it also may violate another law and another law, false declaration before a court, both of which require that the declarant knowingly make false statements under oath or affirming in connection with a federal proceeding. Further, such conduct may constitute obstruction of justice under another law, which criminalizes corruptly obstructing, impeding an official proceeding. A fraudulent affidavit of service intended to mislead the court or to procure a default judgment qualifies as an effort to obstruct judicial proceedings. If the act is part of a broader fraudulent scheme involving the use of mail or electronic communications, it may also give rise to another law, mail and wire fraud, especially where the filing is calculated to deprive a party of property or procedural rights. In addition, such conduct may subject the filer to criminal contempt under another law, as the submission of false evidence to a federal court constitutes misbehavior that obstructs the administration of justice. Yes, attorneys involved in such conduct may also face sanctions under federal rules of civil procedure or disbarment and other discipline under applicable state and local rules of professional conduct. Additionally, it must be said that I do not fear service of your papers. In reality, I welcome them. I recognize from the four corners of your complaint that you make serious allegations. To my mind, if you can prove your case, you will walk away with no less than $5 million. To that end, the first thing I will do, maybe before I send my Rule 11 letter, will be to prepare my motion for you to post a litigation bond. Pursuant to a Florida law, the defendant, Richard Luthmann, will make a formal demand that you, the plaintiff, Jeremy Hales, be required to post a bond in the amount of no less than $5 million as a condition of maintaining this action under the Florida Deceptive and Unfair Trade Practices Act, which is one of the acts he claimed you violated by saying mean things about him. Don't ask me how the two relate. They don't. Only in Jeremy Hales and Randy Shockett's mind do they relate. I assert that the claims alleged are frivolous, brought for the purposes of harassment and without merit, thereby entitling me to indemnification for damages, attorney fees, and costs incurred as a result of defending this action. The bond should be sufficient to secure me, the defendant, against substantial financial harm already incurred and anticipated through the continuation of this vexatious litigation. Based on standard commercial surety bond underwriting practices, the likely cost to you, the plaintiff, for posting such a bond would range from 1 to 10% of the bond's face value, between $50,000 and $500,000, depending on your creditworthiness, collateral availability, and other risk factors assessed by the surety bond. I've also taken the liberty of copying some of your favorite people, including me. To bottom line things, stop telling lies about me, and I'll stop telling the truth about you and your cabal. Also, get your checkbook ready. Litigation bonds are expensive. And since then, Jeremy Hales hasn't said much about the service or you or anything related to you. So maybe you got him to shut up. Do you want to expand on what you were talking about? Can you explain the bond? What does that mean?
7th of July is the last day, the 90th day. And then he may get a few more days because the summons up to me wasn't issued till I believe the 1st of May. So maybe they'll extend it out to August 1st. But there's going to be a notice on the docket that he has to serve me or show cause why he hasn't served me. The fact of the matter is, if they give him more time, they'll try to serve me. I'm not somebody who's going to try to move to dismiss this case. Okay, I'm somebody who's going to answer the case and file a counterclaim against him. Okay, and put in motions. I'm going to hit him with a Rule 11 letter, like I said, which is a frivolous litigation. This is frivolous. I'm going to give you a chance to withdraw it. If you don't withdraw it, I'm going to answer. I'm going to put counterclaims because it's frivolous, and I'm going to also ask for sanctions. So I would put a motion for sanctions in because it's frivolous, and I will put a motion in for him to post a litigation bond. The choice he has is if the judge says, by statute, Florida law says you must post the bond. You must do these factors, and if you make a finding on these factors, you must post a bond. Even if Bolitho or the Article 3 judge makes the determination that maybe it's at most a $2 million claim, it sets that at the face value, you're still talking $20,000 to $200,000 that he has to post, right? So he's in a situation where he's going to have to pay money to a bond company, encumber his property, encumber his houses, in order to keep the Florida deceptive practices claim against me alive. That claim might fall away. Then at that point, if that claim falls away, you got a Langham Act claim. So a bare bones Langham Act claim is conspiracy to commit the Langham Act type claim. And
hold on, for people who don't, what's the Langham Act? What
Langham Act is the same thing that the Florida Deceptive Practices Act is, but it's under federal law. It's a federal deceptive trade practices claim that you can make as a private citizen.
He's saying you making mean statements about him on video and in print is somehow unfair trade practices, right?
And that's totally bogus as a matter of law. And I discussed this last Thursday with Judge Nicholas Mizell, the magistrate judge, on the record in federal court. That there's an 11th Circuit case from the Southern District of Florida with Dan Bongino versus the Daily Beast. And Dan Bongino did the same thing that Jeremy Hales did. He didn't like what the Daily Beast had to say about him. He's a public figure, like Jeremy Hales is a mega influencer, okay? And he turns around and he says, these guys defamed me, but they also trade libeled me, and they committed deceptive trade practices under the Langham Act and under the Florida Unfair Deceptive Trade Practices Act. Well, what did the court in the Southern District of Florida say in the 11th Circuit? They said, guess what, Mr. Bongino? If it's speech, it's speech. The Langham Act and the Florida Unfair and Deceptive Trade Practices Act have to go. They're not there. We're going to deal with the speech. Oh, and number two, you're a public figure, so it's very, very hard for them to defame you, and they didn't. They didn't defame you. The bar is very, very high. Now, I like Dan Bongino. I'm a conservative. I love him. He's an assistant FBI director.
He filed a frivolous lawsuit.
He was 100% wrong in that case. He thought that the law would provide redress for him in that situation, and it doesn't. Especially does not as a deceptive trade practices issue. Speech is one thing. Deceptive trade practices is a totally different animal, and that requires a bond in Florida. On the
Florida. You can't claim speech as something else. They're trying to be cute. You wrote another article about his attorney who used to be a dentist until he committed fraud and lost his dentist license. That's the springboard. What else did you find?
Well, this guy Shockett is just really the bottom of the barrel. And I quoted Bruce Matzke. I even quoted you, some of the things you've said about how this guy. Have you ever seen anybody who has been barred from two professions, for dishonesty?
No.
It's very hard. Bruce says he hasn't. You haven't. You've been doing this a long time. You've seen the worst of the worst in corruption. You
have from two professions.
And so the issue becomes, he was in Missouri, and in the late '90s or the early '90s, late '80s, early '90s, he was doing dentistry work, and he was billing for phantom procedures. And then
Mhm.
they suspended him from the practice for billing fraud. He lied under oath about it in sworn affidavits and continued to practice dentistry without a license, right?
Mhm.
And when they found out he did a consent decree and just turned over his license, but then he
Mhm.
goes and he reemerges in 1995, graduates University of Miami School of Law. That's one of my alma maters, actually. I got a Master of Laws from there. But the University of Miami School of Law, and then afterwards he tries to join the Arkansas bar. Okay, and so he applies for admission to the Arkansas bar and loses 10-1 at the Supreme Court of Arkansas, saying that your background, this whole Missouri fraud thing, is too much. You cannot be a
Mhm.
lawyer in
He was
Arkansas.
also not completely forthcoming in terms of explaining what happened in Missouri as
The
well. So
explanation
he
was no good.
compounded the fraud he committed by trying to minimize to the Arkansas folks the fraud he committed.
And practicing without a license. They
Right.
said you can't practice, you're suspended, and he goes continues to practice, under the table, right, that type of stuff. So that's a
Mhm.
problem. He doesn't obey the authority. Now,
Mhm.
after Arkansas is done in '98, he turns around, and in 2005, he applies for admission to the Florida Board of Bar Examiners, and he's accepted as a lawyer in the state of Florida.
One of two things happened. 99.9% it's one of these two things. Maybe I'm not thinking of something. Either the Florida bar, he was completely honest about his history, including the fraud and being denied a license in Arkansas. And they were like, but we don't have enough lawyers here in Florida. But beggars can't be choosers. We'll let you practice. Or the reason he got accepted is because he wasn't completely honest about his history. We don't know which one it is.
I think we do know what it is because there's a policy in Florida, and I quoted it in here from the Florida Supreme Court. Better that 100 good applicants get denied than one bad applicant be let in, because of
Mm-hmm.
the harm that somebody could do as a dishonest lawyer. And so the fact of the matter is, that's the policy in Florida. That's the stated policy of the Florida Supreme Court. That you rather have 100 good applicants not get in than one bad one get in. The problem that we have here, I think, is it probably relates to dishonesty. He has a pattern of dishonesty that predates the application with two licensing boards, both in Missouri for dentistry and Arkansas for law. He goes to Florida, and there's a problem with now. There's questions about whether that dishonesty was fully disclosed to the Florida bar. Now, that being said, afterwards, he has problems with dishonesty with the Florida bar. In his
Right.
practice of law, he was
And
uh,
that includes in his interactions with me. I filed one bar complaint because he misrepresented someone who was being deposed, Amanda Martin, where she was an employee. She was only an employee in Florida, and he said it was in Florida and Ohio, which I think was a mistake. But when I pointed it out to him, he should have corrected it. The Florida bar didn't care about that, but then he lied about our interactions and claimed that I represented myself at different times as an attorney and as a potential client, even though about a month prior to the interaction that he claims I did this in, I sent him an email stating I was a journalist, and then I kept following up with emails. In fact, I started to call because he didn't respond to emails, and his the secretary or whoever answered the phone, his employee, I said, I'm having trouble reaching Mr. Shockett. And she said, well, maybe you can just do a like a calendar with me. And I said, oh, great. When is he available? And then I made an appointment is the word I was looking for. I made an appointment. At no time did I claim I was a lawyer. At no time were they. One time, the woman presumed I was a lawyer and sent an email saying attorney Michael Volpe. I didn't correct her, but that's the lie he gave that lie to the Florida bar. And I
Mike,
believe they're
you're
still
not you're not under an obligation to correct something, but Randy
Mhm.
Shockett as an attorney is. He
Right,
can't make a false statement until he realizes there's a false statement. What he should have done is said, "Oh, thank you for bringing it to my attention," and correct it.
right.
He's doubling down on saying
And
I'm
it wouldn't
wrong.
have made it wouldn't have, and uh, they ruled in his favor. I don't think it would have made a difference. The reason it was important is because he was deposing this lady, Miss Martin, who had almost nothing to do with the case, and by saying that she was involved in both a matter in Florida and a matter in Ohio, even though it was only in Florida, it makes it look like she's more intertwined with with him and others than she really is. So it's material in that sense, but I don't think it would have changed the outcome of the order. And you're right. Going to the judge and saying, I'm sorry, I mistakenly said in Ohio, I meant only in Florida, like anybody cares. It's a big
If you
deal.
look
It's
right
not,
there, Mike, this is case law. Okay,
mm-hmm,
in Florida, the Florida Board of Bar Examiners. This is people trying to get into the bar. Okay, and there's one with permanent disbarment when they're a bar member. But it talks about the issues about the application process. A single false statement is enough for them to deny. Okay,
mm-hmm.
and then we asked our buddy a whole bunch of questions.
And he
Okay,
didn't respond. He couldn't provide you with any evidence of what he gave to the Florida bar. Would not say if he was honest with the Florida bar about his past and broader ethical questions. None of those he's answered.
and and I think the onus is on him to answer that. The fact is, look at what they did to the Trump lawyers, right? Look what they did to like Jenna Ellis, and look what they did to Sidney Powell. Because you're a lawyer for a public figure, you're open game. He is the
Mm-hmm.
lawyer for a mega influencer. So
Mm-hmm.
in taking the representation, he has to understand that a mega influencer is going to have greater media scrutiny, and therefore his lawyers, who are fair game in public proceedings, are also going to have greater scrutiny. So I think that he has to recognize that.
Right. I agree. So I want to get this up. Give me 1 second. Uh, the next thing we want to talk about is Leslie Federicos. She was for a while gung ho on this Hales case, and then all of a sudden she bugged out. But before she bugged out, she sent Jeremy Hales a groveling email that I want to read. Michael Volpe requested me to do an interview when I had no audience and was told it was merely because I was a retired attorney. Not true. I didn't request it because you were a retired attorney and you said you had a few podcasts that could reach a couple thousand people. I was forced to endure horrible cyberbullying directly after that interview. Not true. There was no cyberbullying after the first interview. I attempted to be neutral by reaching out to Megan Fox, my former friend, to interview her, but did not get a response. That's true. I was defamed about my professional retirement status. True. Regardless, all I ever wanted was it to stop. I am not here seeking revenge nor profit. I am willing to drop the lawsuit if everyone will please stop misrepresenting my retirement status. I am not about money, never was. She voluntarily retired. She wasn't disbarred. She didn't retire because she was about to be disbarred. She did have bar complaints brought at the same time. She went up against Dory Foster Morales, then the outgoing president of the Florida bar. That I don't believe is a coincidence. But be that as it may, she retired because they were just going to keep going after her and after her and after her and make it miserable for her to be a lawyer. That's why she retired. I am not about money, never was. I came from money and walked away from it with my own family. I reached out to you previously, trying to help you remember the roots in God you came from. There is nothing more for me to say. I do not hate you nor wish harm on you. I am the same age as you with many similarities. We both have adult children who reject us. We both have parents who reject us. We were both born the same year of 1977. Please do not respond to me with hate. I do not hate you nor wish harm on you. Life is truly hard. None of us are perfect. I apologize for ever judging you. I was wrong for that. I am here if you ever want a true friend because I believe we are all connected through God. Pathetic, Leslie, but that's not nearly as pathetic as you dropping the lawsuit you filed 6 weeks prior because you claimed they defamed you. And Leslie, every decision was yours. I did ask to do a podcast. You didn't even have to do that. I just wanted to do one podcast. You decided to do a second one. I think that was with me and you. You then decided to do a third one. You then decided to make satirical videos under a pseudonym. You then decided to come on weekly on Lisa's show on Two Lees in a Pod. You then decided to make your own show called The Jury Room. And then you keep saying, I want the attacks to stop. I'm sorry. Are you serious? Are you effing kidding me right now? You went full force with both feet and are wondering why they're attacking you. And you keep asking them to stop, even as you are attacking them. That's not how this works. And you do not file a lawsuit and then dismiss it 6 weeks later. That is unprofessional. I believe the lawsuit has merit, but now it looks like a frivolous lawsuit. And by the way, he turned around and within, I think, real time, sued her from, I presume, malicious prosecution, saying that she filed a frivolous lawsuit against him. And he may have some legs to stand on since you dismissed it 6 weeks after you filed it. Leslie, you helped no one. You're not helping yourself. You didn't help Michelle Preston. You didn't help John Cook. You didn't help the truth. You didn't help justice. What you did was you thought you could fight and you couldn't. And when the going got tough, you tucked tail and ran. You know what? You know what this is like? I got a great analogy. You ready? This is like 1997 Game 5 in Utah. Michael Jordan's got food poisoning, except you know what he does? He stays home. He doesn't even go to the arena. He's like, you know what? I'm too sick. I'm not even going to get anybody sick. I'm just going to stay in the hotel. And then the Bulls, because their best player is sitting in the hotel, they lose Game 5. They go back to Chicago. You know what Michael Jordan does? He doesn't even show up in Chicago, and they lose Game 5 and 6. And Utah becomes NBA champions. That is the analogy to Leslie Federico's in this case. Your thoughts?
I think you're still bitter about those finals, Mike. I think you are.
I'm not bitter. No, that was great. That was great. Utah might be bitter though, but I'm not. But yeah, no.
I have a slightly different view on this. I think that Leslie is the victim of Jeremy Hales. Okay, even though the way she's handled it, you don't like it. I think that she's still Jeremy Hales' victim, because that's evidenced by the second that she pulled back the cases, the next day Jeremy filed a case against her. Right. Jeremy is a maniac, and you can't really fault her for trying to think that she can deal with the maniac, other than the fact that she should have known better than dealing with a maniac. So I think that yes, it's not probably the best way she could have handled it, because of hindsight being 2020, because Jeremy turned and basically took her kindness for weakness. She wanted to be just done with this with Jeremy and not be harassed by him. He actually got Leslie's father. They've been estranged for many years, and for good reason. There's a lot going on with that family. And Jeremy tried to get the father, and was talking about the father and her entire personal life in the context of Jeremy's show.
Yeah. Jeremy is trying to talk to my ex-girlfriend, the mother of my son. So what?
I know that.
That's what he's like.
Mike, I know that. Hey, but you recognize the only way to stop a bully is to hit them in the nose and go head on again. Leslie thought that by agreeing with them that she would stop her lawsuit, and that agreeing that they would honor an agreement. This guy can't be trusted. He's slippery as shit. Okay, that is what he is. That's an official legal term, slippery as shit. You cannot make an agreement with this guy that this guy's going to honor, so you have to take him to the end. Okay, that's what you got to do.
Or don't start it.
Remember the Mortal Kombat video game? Finish him. That's what's going to have to happen to Jeremy Hales legally. That's really what's going to have to happen.
All right, we're moving on to some of the stuff that you and I work on. And yesterday we interviewed Idaho State Senator Tammy. Oh, you know what? I did this wrong.
This was huge.
Idaho State Senator Tammy Nichols, who is co-chairing, I think co-chairing is the appropriate term, the Idaho Child Custody and Domestic Relations Task Force. They had their first hearing on July 7th. They have their second hearing on July 31st. It was in depth. We'll probably go over more parts of it, but I got one part. This is, I don't know, he runs some sort of magistrate nonsense, and he's going to talk about how magistrates are selected in the state of Idaho. I'm going to describe how magistrates get selected.
Is Ada, Valley, Elmore, and Boise County. So each one of those are chairmen of their various commissions, or designee. In this case, they're all chairmen. And then you get down to the attorneys, which I think is kind of interesting, because the Bar Association, a private organization, makes these appointments. Did you know that? They make these appointments, and then the governor makes the balance or some of these appointments. There's.
All right. I think that's something you can work on. Why is the bar making appointments for magistrates?
Yeah, I feel that there needs to be a bit of change in regards to how judges are being appointed.
All right. That right there is a great thing that came out in this hearing. I doubt most people knew that. And now they know that magistrates are appointed through the bar, but they are going to have to pass legislation to change this. And I do think it's coming. I have people on Facebook, why can't they fix it? The legislative process isn't a real-time process. It takes time. I understand that kids are in danger. that courts are violating people's due process, people's rights, that they're handing kids to abusers. I understand that's happening all over the country, but it takes time. But that State Senator Nichols recognized that's not good. You get the bar selecting some, the governor selects others, magistrates, judges. But I'll tell you this, I haven't done that many stories out of Idaho, but every single one, I didn't see one full judge presiding over any family court case that I've been working on. So it seems like they get the bulk of the duties in these family court cases. And we're getting on to something. Did you want to talk about that part or any other part of the interview? What'd you think?
It was great. I thought that the fact that Idaho is doing this and Senator Nichols and her group are really coming and looking at things. But she talked about a lot of the issues there. And she talked about some core things that they're doing. A lot along the lines of Senator Fincham in Arizona. We talked about transparency, and she talked about orders and the temporary orders. I think that was the most important part of that's
the most important part, because we've interviewed State Senator Mark Fincham from Arizona, where they have a similar committee, and State Representative Rachel Keschel, and they both talked a lot about how these temporary orders are screwing things up because you cannot appeal them, and they are being used as permanent orders. So it looks like
let's explain what's going on. We talked about it yesterday. What happens is you come in with a temporary ex parte order, which means that you ask for, which means that you're one side that's coming in saying there's an emergency with respect to the child custody or with respect to violence or with respect to allegations against child safety. And one side runs in with their lawyer without the benefit of the other side being there. And you have one of these magistrates who sits there and they say, oh, wow, you're saying that these kids are in danger? And they sign right away. Because what magistrate is not going to sign an order where they're saying that the children are in danger? That'll be the end of their career, okay? So they sign off on the order. Then the order itself, you're supposed to have a return date on this temporary order where both sides can present their stories, but that date never happens. It gets adjourned and pushed out and everything else. Some cases I've seen that where this temporary order gets pushed out, way into the future, where they can have a return date, but there's no full hearing on it or anything else. And then that temporary order gets put in, and it's a year later, and then the lawyer turns the tables and says, well, judge, this temporary order has been in place for 1 year, therefore it's the status quo. And why would we disrupt the status quo? And once a magistrate hears the status quo, they're going to say, well, I'm not going to disrupt the status quo. It's kind of like, it's a race to have the best lawyer and have the most egregious violation.
We have on the screen from the case that I covered the most, a temporary order from 2012 in Dakota County, Minnesota, written by an obscenely terrible judge named David Knutson. And let's mention some of the other people here is Judge Knutson, Elizabeth Henry laid down for her client, Sandra Gazzini-Rucky. Lisa Elliott is a terribly corrupt lawyer. Julie Friedrich is an obscenely corrupt guardian ad litem. Paul Reitman was the impetus for this order, but you're going to love this. A temporary order. You ready for this? Here we go. The children's aunt, Tammy Love, or another individual, as recommended by the guardian ad litem, shall have temporary physical and legal custody of the minor children. There were 5 of them. Tammy is the father's sister. Tammy shall move into the Iron Place. That's the home where at that time the mother was living, and will reside with the children at their home until further order of this court. The children's aunt, Nancy Olson, may contact and visit the children to assist Miss Love or other individuals as recommended by the guardian ad litem. Neither party, that's the 2 parents, shall have any contact with the minor children. That is a temporary order that held until April of the following year, when only the father was allowed custody. And on the date of that order, 2 of the 5 kids, and no, I'm sorry, they gave it back, I think, to Tammy Love, and 2 of the 5 kids, but they knew that the father was going to get custody. And the 2 oldest daughters, Samantha and Gianna Rucky, ran and were missing for 2.5 years. And hold on, I got to get, where is it? Here we go. Honor before, at some point in here, he threatens that the police will get involved if she doesn't leave the place, and that's a temporary order. And this is what you're talking about. This is an example of it. This wasn't done ex parte, but it was done after a hearing where neither parent was there. Their lawyers were there, and it wasn't a hearing. They called it a telephonic conference. But basically the same kind of thing. There was no actual hearing that determined this, and there you go. This is an example of what you're talking about. Go ahead.
So these orders are really detrimental totally to the to the system. It's like what Senator Fincham said, what Representative Cashel said, and what we talked about here was that there are two types of determinations that need to be made: a custody determination and a property determination in a domestic relations matter. And this doesn't; these attenuated orders that are not acted upon only create more hazard than they seem to resolve in many cases. So
right.
they need.
And look, neither party shall have contact with the minor children electronically except as recommended in writing by the therapist. Violation of this no contact provision shall trigger a contempt proceeding with possibility of incarceration. This judge, without the benefit of a hearing, told both parents not to contact their children in any way. And if you do, I'm going to put you in jail.
Yeah.
And that is a temporary order. It's exactly what you're talking about. All right, go ahead.
And so the issue is, and the issue here is that you can resolve this with legislation pretty easily. And most states do it. If they can say that the resolution of a temporary order, a hearing on that takes precedence over all other civil and criminal matters. They do this in other areas of the law. I know in election law, if you have an election law case,
so
they
there
stop
needs to be a
trial.
Right. There needs to be a law that says now that there's a temporary order, it must be dealt with quickly. No more than 90
and so there's
days.
two things. It takes precedence over everything else on the calendar. And number two, it needs to be dealt with within a statutory period of days. So if they say 30 or 60 days as a statutory period, judges will find a way to judicially add another like 30 days or so, or 15 or 30 days on it to say that there's a reasonable time. But the fact is, if you put a cap on this thing and you say 30 days, the hope is that within 60 to 90 days, in the worst cases, the thing will be resolved, because you always have to make provision for counsel being sick or somebody being out of town. But you have to do this first. It's on the top of the calendar. There's no excuses. There's no other cases that take precedent, and that there's a time frame.
Right. I agree. And she did propose that as a law. Another thing she proposed is she called it an anti-SLAPP-like law to deal with egregiously false allegation. If I understood her correctly, that if an allegation is proven to be false and you believe that it was deliberately false, that you have a fast track where you can present it to the court, and the person who filed the false allegation has to meet a minimum threshold. And if they don't meet of evidence, if they don't meet that, the allegation will be deemed deliberately false. And then through legislation, there will be legislated statutory consequences. Did you understand it the same way as I did?
Yeah, I think that they have to follow the law. The judicial branch has to follow the law. And so
no, but did you understand that that's the law she wants to get passed? That you have like an anti-SLAPP.
Well, and that makes a little bit of sense, but it makes
no, wouldn't
not
that,
a lot of sense.
But wouldn't that be?
Issue.
But don't you? And this is the same question I asked her. Wouldn't that be exploited by abusive people who have the ear of the courts, and the courts are going to constantly say there's no abuse, and then suddenly now they got another tool and say we're going to deem you a false accuser, and you bring in text messages, emails, medical reports, and the judge says that there's no evidence here. There's no reason for you to have believed that your ex-husband was beating your kids. I'm going to deem this a frivolous false allegation, and now we're going to keep you away from your kid for 90 days. I do worry that's what's going to, the law of unintended consequences, that's what would happen.
Like I look at some of the egregious cases, like the craziest Darbo abusers and the craziest psychopaths. Look at a case like Christopher Ambrose. I don't think that the Tammy Nichols putting in like an anti-SLAPP type rule would have stopped Christopher Ambrose. In the sense that he was able to totally have such power structure because of his background as an NYU law graduate and lawyer, and his money to run roughshod over Karen Riordan, a school teacher. And so you have a power imbalance. It doesn't matter what the law says. And the law might be well-intending. That might actually, I could see an abuser like Christopher Ambrose weaponize an anti-SLAPP type producer the same way he weaponized coercive control against a 110-pound school teacher. So I think you're 100% right there.
Right. They got to be really careful about that. I wrote an article where I talked about the laws she's proposing, and they're all ideas right now. And we might talk about it next week. We debated a little bit about the efficacy of 50-50, but you also have an update into the Dinesh Noshirvan, the notorious Supreme Court doxer who ruins people's lives. A Texas coach committed suicide after his roughshod campaign. You were suing him because he called you a pedophile, even though there's no evidence you're a pedophile, and actually being convicted of child molestation in the state of Florida, where you reside, is death penalty worthy under a relatively new law. So very serious. You had a status conference. I know why he skipped it, because they're very, very boring.
Actually, Judge Mizell, Nicholas Mizell in the Middle District of Florida, he's the magistrate. He was just phenomenal, just a phenomenal guy. I actually had cases in front of him before, and he remembered. I saw you for this, and I saw you for that. I'm like, oh, great. The guy was like on the ball, and he went through the entire thing with me, the entire complaint, and he said, listen, let's just get to the cut to the chase here and draft this and do this the right way, and here's what we need to get done. And he was just a matter of fact and old business, and I couldn't have been happier with the service that he gave as a judge.
He also issued an order to the man who didn't want to be bored afterwards, because even though they are boring and I don't know, they're very boring, but you're still kind of required.
He's a defendant. He's obligated to show up, and he's obligated not to waste everybody else's time, and especially the judge's time. The judge spent over.
And where did you find out? Where was he?
Well, take a look here. This article and the other article. If you go down, I think the order might be in here. I copied the order itself. But this is about the Hilton Grand Vacations, Alara on the Vegas Strip. He took a West Coast vacation, and he went out to the Strip, and he had a big thing. First, he started in Los Angeles, and when he was supposed to be with Judge Mizell, he was actually on a podcast in Los Angeles. And the other, but if you go down further, I believe that the judge's orders in it. The judge was not at all happy with Dinesh, and Dinesh and his wife. Well, here it is, the text order.
I think this is the order. Let's read that. Defendant Dinesh Noshirvan failed to appear for an in-person Rule 16 conference scheduled. I think he meant 2025. Yet he never requested a continuance, nor did he contact the court. In addition, Noshirvan failed to engage in a planning conference and file a case management report in violation of our local rules. Then he cites the rules. The civil action order also directs the parties to meet and confer about selecting a mediator when filing a CMR, but Noshirvan ignored that directive as well. As such, by August 1, coming up, 2025, Noshirvan must show cause why he should not be sanctioned or held in default for failing to appear or otherwise defend. Noshirvan's show cause response must be under oath and corroborated by something other than his personal statement. And this is a magistrate again, Mizell. Do the actual judges picked by the president ever handle any of these cases, or is it?
Well, they handle this stuff. The magistrates all do this first and everything else. I don't know. I might litigate the issue. I don't know. Mizell has been very good to me so far. And I told him in court. I said, look, he said, like, I like the goose gander rule. I said, what's good for the goose is good for the gander. He said, well, in this court, we like the goose gander rule. And if he's going to treat me well and he's going to treat Dinesh well, we have a fair playing field. That's what I want. That's all that anybody can ask for in the federal courts, and I think that's the hope is that you walk into the court and you get a fair shake. But this article it shows that Dinesh was in Las Vegas. The previous article shows he was in Los Angeles, and the problem is that he's a commercial pornography producer going to a Hilton Grand Vacations facility. And I was asking in that article whether or not the Hilton Grand Vacations had done any type of policy about that, because he's talking about finding people and everything else. There's an issue about harvesting. He's not a professional private investigator, and he's not a police officer. He's got no law enforcement experience. What kind of people could he be finding at the Hilton Grand Vacations Alara, other than more content creators for his thing? And that's a courtroom sketch of Judge Mizell. Very, very nicely, very friendly man. And,
All right.
you know,
And we're waiting for our guests, but in the meantime, we can go through the original article, which you explained. So give you another view. And there he is on the podcast while he was supposed to be in court. It's really a bad idea, folks, to miss court. Don't do that. You're going to put yourself way behind the eight ball, figuratively, if you miss court. And this is going to become a very big problem for Mr.
but he missed court, and then he did a public podcast to boot.
Right.
It's not like
And
he was someplace else. And if he puts in something else, it's like clear perjury. It's like, you know, that's the whole problem with this guy. He knows that's him going out of the court. He knows what the court is.
The judge is asking, right. The judge is asking him to explain why he wasn't in court. Am I right?
Yeah. Where were you? Where were you? How come you tell anybody you were here? How come you didn't file the status conference? How come you didn't confer with Luthmann? How come you ignore him? How come, like, listen, I already said it to the judge. Mm-hmm. Dinesh would do an apology to me from the highest mountaintops, and the same way he defamed me to his 3 million people. He's a mega influencer, saying, I said these things about Richard Luthmann. I was wrong about that. Richard Luthmann is not a pedophile, a child stalker. He's not a danger to children. He's not this. He's not that. I would be, I would consider a resolution. And
he's not going to do that. That doesn't fit his brand, so he's never going to do that. I think we've done enough on Dinesh. We've got our guests, and they are Jackie Sample and Roy Johnson. They're both in Jackie's home, which is a lovely home in Fur Ridge that she built. And we're going to have both of you guys on because we got a really interesting case. Roy, you found Jackie because your brother was put into guardianship based on an order by Judge James Orrell, and the same Judge James Orrell was violating Jackie's rights left and right. I watched one hearing where he treated Jackie like she was pawn scum and everybody else was getting respect. Man, woman, black, white, green, everybody else was treated respectfully. But before that, I'm going to get an article up on the screen, but specifically, Jackie, there was an incident that's going to directly relate to what happened with Roy, where Judge Orrell suggested or tried to push a lawyer to put you into guardianship. And we won't say your exact age, but you're early 50s. You've had a successful career. This is almost as egregious as putting Britney Spears into guardianship. So describe what happened with that. And while you do that, I'll get an article up on the screen.
Yeah, so I was homesick for this particular court appearance and later found out that the judge pushed very hard to have this attorney put me into a guardianship, like multiple times urging her, saying if I still reside in DuPage County in 7 days, do it now. I have no medical issues that would warrant me to be in a guardianship. So, yeah, and this was Judge Orrell.
Right. And so it didn't quite happen. And in a couple of minutes, describe how Judge Orrell screwed you over, for lack of a better word, in general.
So when my case came to Judge Orrell, I filed for to reinstate the financial status quo, as well as enforce.
Now, before you say that, what your ex-husband, Dr. Madison Sample, who was very successful as a doctor, and also you guys did a lot of investments in crypto and other things that were very successful. He moved a lot of that money. And basically, by the time he filed for divorce, there was almost nothing left in your joint accounts. So when you filed for a status quo, it was basically to move the money back, right? So you could have access to what was yours. And so how did Judge Orrell treat that?
Yeah, so actually he started moving money after the court order was issued. So there was still over 5 million in digital currency. There was still money coming into our bank accounts, still marital investments in companies like CareScore and other companies. So after there was an order issued on 4/11 of 2023, my husband Madison decided he's above the law. He's not going to adhere to any court orders. So then he started closing accounts, locking me out of our digital currency accounts, and just locked me out of everything financially. And when I started filing to have these things addressed and enforce the court order, Judge Orrell would never enforce a court order. He would send me home penniless, knowing I didn't have money.
Didn't he kind of laugh about it at times?
Yeah, there's one particular occasion I said to him, I don't have enough money on my Link welfare card to buy food for the month. and he smirked as though it was funny. I gave him cutoff notices because I didn't have money to pay the utilities. They smirked at this. So I would go home dealing with my utilities constantly being shut off, not having enough money for food for the month,
And
having work
and we
restrictions.
should note your home is worth $2-3 million, maybe more. So you're living in the lap of luxury. When you were married to Dr. Sample, you guys were elite financially, top 1%, maybe even higher than that. So he, or your husband, first and foremost, his attorneys, who for a while were Bierman, we've done a lot on, both Rich and I, are also responsible. But Judge Orell was allowing this by constantly looking the other way when you were asking to reinstate it to what was fair and what the law requires. Because you guys accumulated all of this wealth during the marriage. You are entitled to half of it. And it doesn't matter that he was working and he was the primary breadwinner. That makes no difference. Jeff Bezos didn't make that argument. Nobody makes that argument. And Orell was basically not only denying you, but at times laughing at the financial situation that you were put in, right?
Absolutely. He actually accepted falsified financial affidavits. So my husband, Madison, submitted forged affidavits on 3 separate occasions, and the judges accepted it and looked the other way.
Okay. And Roy, your brother was put into guardianship by the same Judge Orell. Right now, and your brother's name is what? Roy, can you hear me?
Oh, I'm sorry. I thought you were still referring.
No, right. First of all, what's your brother's name?
His name is Raymond.
Raymond Johnson, and he's no longer alive, right?
Yeah, he's correct. He died on the 2nd of August.
All right. Now, do you think that what you're about to describe has anything to do with his death?
Well, Judge Orell simply disregarded the law, did not even give a notice, which is required by law, for 15 days prior to.
Well, wait, hold on. You're getting a little. Explain what happened. First of all, I think you two were living in the same property, and so how did it come about that anyone wanted him in guardianship, and then get to how Judge Orell was involved?
Well, it turns out that the information that we needed to give to the various agencies was used by the guardianship to find people like my brother who had property but was being denied an income from, in this case, 2 rental homes that were not being paid by the tenants. They did not pay any rent for 2 3/4 years. And yet the Illinois government has an allotment from the federal government to pay the back rent, and the Mr. Pritzker refuses to do that. So
I think what you're suggesting is the government initiated a guardianship proceeding against your brother because they wanted to pocket the federal rent assistance that they were supposed to giving to him.
yeah.
All right. So how did the guardianship initially come about? How did that happen?
Well, the governor actually appointed Mr. Matthew McQuaid, and he is very busy in attempting to steal as much property from normal people who are elderly. Let's put
Hold
it
on, Matthew McQuaid. What is his job title?
He's the director of the guardianship.
Okay.
He has a group of attorneys that also do some work that is illegal.
Okay.
They proceed on a regular basis. And they even put up on my brother's property, which was actually half mine, because myself and my brother built the house. And they actually put up notices stating that if I were to come there, I would be subject to arrest by the sheriff that we
Okay,
had.
but hold on, you're getting a little off track. How did the guardianship come about?
Well, that was invented by Mr. McQuaid
All
to,
right, so McQuaid filed a petition to put your brother into guardianship, right?
yes, yes,
All right, and then that petition lands in the courtroom of Judge James Orrell.
yes.
So describe what Judge James Orrell did when your brother's petition for guardianship. What kind of hearings did he hold? What evidence did he allow to be presented? What witnesses testified? What happened?
Well, he actually worked off of false evidence
Mhm.
and, for several items. But the basic thing is that he was in ex parte conversations with Mr. McQuaid, and no one else was there to voice opposition. But you can see that it was a open and closed shut case for them because nothing was done according to the law.
Mhm.
And so the guardianship was attained
Mhm.
illegally.
Well, what do you mean? You explain in more detail how the proceedings went when you say illegally. What do you mean by that?
Well, there was no opportunity for me or my brother to speak.
Wait, the hearing that ultimately determined that your brother was, they call it incapacitated. Did your brother attend?
No,
No. Did
he
you
could not
attend?
attend. It was during
Right
the
now, did you attend?
no, because
Who,
there was
if
no
you know who did attend?
no one.
Well, somebody had to be there. What was it?
Well,
Just James Orrell by himself?
only Mr. McQuaid.
All right, so hold on. So the hearing was Judge Orrell and Mr. McQuaid presenting evidence to Judge
Yes.
Orrell. All right, so it's a fixed case. So Judge Orrell then puts him into guardianship. What were the financial and maybe medical consequences of your brother being in guardianship?
Well, he had been diagnosed approximately 6 years earlier with Alzheimer's, but he
Mhm.
was also functional all that time, including until they actually came to abduct him out of my house.
All right, so he continued to live with you even though he was put into guardianship, right?
Yes.
All right, but then sometime later, how much longer before the so-called abduction happened?
It actually took place about 2 months later. And that's when they came with the Downers Grove Police Department, the fire department, the guardianship, of about 3 members of that, and some others were standing around there. I'm not sure who they all were, but there was about a dozen people in my front yard. And they said, if you don't give him to us, we'll knock down your front door and take him anyway.
Okay. And then what was the financial consequences of him being in guardianship? Like what happened to the real estate and all of that?
The guardianship immediately put up the notices on the doors of his house.
To
And
sell it,
immediately,
right?
the ones I described earlier.
All right. Now, in your complaint, you repeatedly refer to J.P. Morgan Chase, my bank. How is J.P. Morgan Chase involved in all of this?
Well, they were not allowed to foreclose because of their criminality. If you can verify that, they've paid out since 2010 $40 billion in fines to the government for their
But
criminality.
that's in general. Obviously, J.P. Morgan Chase is a big company. They've had some fraud issues, but how did you say they obtained your home through fraud? How is that? Or the mortgage through fraud? How did they do that?
Well, there's a law in the state of Illinois as well as federally that states that any criminality howsoever caused will abrogate the.
Yeah, but what criminality do you think that Chase committed?
Well, they were committing these crimes continuously, and
But what?
the
Wait,
mortgage
try to be
contract.
specific with some of the crimes that you think they committed.
Well, for example, the last one I read about
Right, but
New
that's
York.
in general. Did they commit crimes against you?
Yes,
Which one? Give me one or two.
They did actually both loans for myself and my brother were taken and given when we had no significant way to pay them back.
All right, they gave you predatory loans, so they
Yes.
shouldn't have been able to foreclose. All right,
Exactly.
and then recently, I think a couple of months ago, you were involuntarily committed. What happened there?
Well, that was I went into the Good Samaritan Hospital for an infection, and when I was about to be released, they had already given me the signs that they were going to release me, and I was dressed and ready to go, and I can't remember her first name, but it's Aman. She's the director of the psych ward at the Good Samaritan Hospital.
Mhm.
And she wanted me to repeat some of the things that I had told some of the nurses who were inquiring what my problems were, you know. And so I didn't feel anything wrong about discussing them. But of course, they told their superiors in the nursing department, and the nursing department then called Dr. Aman, and she then came and said, "Well, we want you to go." And I told her, you know, I do not want to go with them, but they had two policemen there who actually forced me into a situation that was actually an abduction.
And how much time did you spend in the psych ward?
About 5 or 6 days.
And how did you get out?
Then my realtor and my attorney, who I had just hired recently prior to that, called them, and they also then agreed to let me go because what they had claimed was miraculously cured in 5 days.
And they let you go because you needed to sign some paperwork to
Oh,
close the
yes,
deal.
I needed to sign some paperwork to save some property from being.
So all of a sudden, you're no longer crazy because you need to sign some paperwork for some real estate. Now, let's get to the present. Earlier this month, both of you, not represented by counsel, were in, I think it's the Dirksen Federal Building. Am I right? Is that what they call it? Is that, what was the judge's name that you were in front of?
Our judge is Judge Andrea Wood.
Andrea Wood, who was, and I'm going to get a photo of her up on the screen, and she was appointed by President Obama. Now, you both have like state cases. So before you describe what happened, and there's your courtroom motion practices, etc. Why were you in federal court? What were you trying to accomplish in federal court? Let's start with you, Jackie. What were you trying to accomplish?
So the events of the state court with violation of due process by 4 different judges and one judge we have in common, Judge James Arrell, just led to the lawsuit. I spent 2.5 years with every judge in a coordinated effort, it appears, to keep me penniless and to protect Madison.
All right, so you had your 14th Amendment rights, I'm assuming, violated.
Yep.
So you were arguing federal issues. Why were you there, Roy? Why were you in our courtroom?
Well, this essentially the same thing, the type of.
But you were trying to be an intervener. Am I right? What is that?
Well, in this case, I was intervening because to support the same situation that she was dealing with, and it is by the same judge. And so if that isn't a connection, what is?
All right, Rich, you've been quiet for a little while. Intervener, legally, what does that mean?
That means that you're an interested party, that there's a pending lawsuit, and you're intervening into the party because you have something that's materially relevant to the case. So,
okay.
Yeah.
All right. So I'm going to get up Roy's motion on the screen. But there is the Obama appointee. You just saw her, Andrea Wood. Jackie, we'll start with you. Describe in as much detail as you can remember. And what was the date of this hearing?
It was July 16th, I believe.
All right, we're a week out. What happened? What about what time? 9 a.m., 10 a.m.? What time of the day would you say it was?
Like 9:30 a.m.
All right, what happens? You're in front of Judge Wood. What happens?
So we did a phone hearing, it was
Mhm.
a phone conference hearing, and she addressed Roy's motion to intervene first.
Mhm.
And Roy did state the connection.
There-
However,
Explain what happened when you were in front of her.
I'm sorry, are you talking to me or Roy?
Yeah, to you, Jackie. We'll get to what happened with Roy, even
Oh,
though
so,
it's not a time
okay.
order. I'm going with you. When you got in front of, or by phone in front of her, what happened in as much detail as you can remember?
So when it was my turn, I was initially questioned about whether or not this was the same lawsuit I had filed back in December that was dismissed.
Mhm.
And I stated that to my understanding, it is not. So I explained that a couple of times, and
Now explain the previous lawsuit and then how this lawsuit is different.
so the previous lawsuit I filed was against the attorneys that were the actors. I did not name any of the judges as the defendants, but I did put their actions in the lawsuit. This particular time, I listed the judges and I did not list the attorneys and their actions. So to my
All
understanding,
right, so you were suing a whole new set of people,
that is
right?
correct.
All right, sounds like a different lawsuit. Okay, so you're explaining this. What happens next?
So then we get to the motion to dismiss the counsel for the judges.
Mhm.
This counsel is the assistant attorney to the attorney general's office, which from my understanding would be a conflict of interest, that you can't represent judges when they are acting outside of their jurisdiction. To my understanding, when you're not following the Constitution, you're no longer covered. You no longer have immunity. So I
Mhm.
did present a motion with the law, facts, and codes.
Mhm.
And this attorney argued back that there's no conflict of interest because he had never represented me or I was
Mhm.
never his client. Well, that
Mhm.
wasn't my claim. We have no connection. However, the judges are not acting within their official capacity because the whole lawsuit is based upon these judges not honoring to uphold the Constitution.
Mhm.
Again, that's a matter we addressed. And the judge said she would give that some thought. Um, and then there was one of the attorneys from the bank, which mentioned that they may file a motion to dismiss their case. So we set dates for those things, but at the end of it, I did not get an opportunity to present the most important motions. I submitted a motion for an emergency injunction due to being a victim of domestic violence for
Mhm.
like 2.5 years. I have failing health issues that I can't address,
Mhm.
lack of food, lack of resources for work,
Mhm.
utilities constantly being shut off. I was just in a hospital for almost a week. If I had access to my funds and due process, I wouldn't face some of the health issues that I'm facing. So we didn't get a chance for me to present those motions, but I was told by Judge Wood that she knew what I was asking for and they would be addressed in the order.
And were they addressed in the order?
Not to my knowledge, I didn't see them.
Now, you described her behaving badly. Can you describe some of the bad behavior that she had?
Um, just notice that it seems like the other side counsel was just given more favoritism
Well,
than.
explain, give some more detail. Explain
So
that.
I'm the one that filed the lawsuit complaint in the first place, and then I filed these motions, these emergency motions, because of the immediate issues I'm dealing with. Yet
Mhm.
these other attorneys, they get to address what they want to address, and
Mhm.
then run out of time, and I don't get to address my issues. That's one thing. And the attorney for the judges had mentioned that he was going to file to dismiss the case because of improper service, but then he
Mhm.
decided he was going to accept service, yet
Mhm.
still setting dates for him to file his motion to dismiss. So at that point, I asked, why is he going to file a motion to dismiss? He just said he's going to accept service.
Mhm.
Um, the attorney kind of briefly answered, and then the judge stepped in and sort of helped with the answer. It appears that there was help with him with the answer.
So
In the meantime, I haven't
you
any help.
you you found several examples where she was acting as an attorney for the other side. Am I right?
Well, that is one particular situation that I noticed, that there seems to be help.
Well, explain, give another example.
I have to think of another example. Let's see.
All right, well, why don't we get back to you then, Roy? You filed, and we're looking at it, your motion to intervene, and how did Judge Wood treat you?
Well, she disregarded the fact that the attorney is the same, the judge is the same person, and that
what did she say? Hold on, what did she say specifically? What was the exact quote?
Well, I actually cannot read that right now.
No. What did she say exactly? Not what's the exact quote of your motion. What did she say when you tried to intervene? What did she actually say to you?
She said this is not something that there's no connection here.
But you said the judge in your case put your brother into guardianship, and the same judge in her case tried to put her into guardianship.
Exactly.
So
yeah.
How did she respond to that?
She didn't. She didn't respond to it. She just babbled onward and showed favoritism, as Jackie was suggesting. She simply wanted to get rid of the motions as quickly
hold on.
as possible.
You're being a little vague. When you say showed favoritism, explain specifically how she showed favoritism.
Well, everything that Jackie just said, I reiterate here, because that's exactly what was happening. The judge, as soon as I heard her speak, I could tell she had an attitude that was very oppositional. And so, I mean, that's an apparent thing that I'm used to being conscious.
Didn't she say just because you think the facts are a certain way doesn't mean the facts are a certain way?
That's the way they turned out. Yeah, she disregarded what I did say, and so she just went on about her business as quickly as possible. By the way, this is another attitude I want to talk about. Judges in general, but her in particular, and Judge Orell, what they do is want to immediately tell you that they've got other cases to handle, and we're out of time. Slam down the gavel and get out of here. That's their attitude.
And she did that to you.
She didn't say get out of here. No.
But she said we're out of time. Right, but she said we're out of time.
Yes.
Right. All right. After how many minutes?
Well, just a matter of probably no more than 2.5 to 3 minutes.
All right. But didn't she say?
No, I'm talking about for my little section there.
Right. So she only gave you 2 to 2.5 minutes to argue your case, and then dismissed it, saying there's no connection here.
Yes.
Right?
Yes.
Okay. And didn't she say something like, just because you think the facts are this way doesn't mean the facts are this way?
Well, this is, in other words, my opinion was meaningless to her, even though I'm a board certified hypnotherapist.
Well, even though, Rich, isn't at this junction of the case, isn't his presentation of the facts supposed to be treated as if they are the facts because it's early on in the process?
Yes.
Right?
It's a little bit different with the intervener. It's like you have to show a clear nexus to the case, and you have to show that you have to bring the case itself. What the court might say, and they might properly say, is that, look, you could bring your own petition to the court, and then we could consider your facts and your claims within the four corners of a pleading as compared to the other pleading that Jackie has. And then you could enter what's called a motion to consolidate or motion to join the cases on issues of fact or law that are the same. But the intervener itself, it's got a higher standard than that. What you're talking about is to take things as true. You're better off, but you're not a lawyer. You don't know this stuff. You don't know that and you're trying to get it in front of the court as quickly as possible in the lowest cost way as possible and bring the relevant information. But the procedures are a little bit crazy sometimes. They only let an intervener in if it's a clear interest, and the judge didn't allow you, appears, to make a record to try to even say that you had an interest in the case, in the other case. So that's a problem. It's a problem.
All right, but if the same judge violated his brother's due process rights by holding a hearing without him there, and Jackie is arguing that James Orell, the same judge, is violating her due process rights, isn't that a clear case to intervene? Because he's showing the
No,
pattern.
it's not. It's linked facts. Okay, it's
Mhm.
linked proofs. And so what I'm telling you is the proper way to do this is to Jackie to bring in as a witness or to bring in the evidence and everything else. Now, if there's a separate claim, what you may be able to do is bring another claim about the brother and then file that claim against the judge and then move to consolidate the two cases and join them for common issues of fact or law. And what you're trying to say is there's a modus operandi here that this judge is engaged in. He's in some type of corrupt modus operandi. But be warned, you must be able to cite material facts outside the four corners of a legal opinion to do that. Legal opinions have judicial immunity. Okay, so you have to show that there are things outside of the four corners of the agreement. We saw this with the Gerard case. They're moving on the judges, and they're talking about a whole conspiracy with judges. You have to talk about something outside what the judge's decision was. It's not the decision that you have to gripe with. It's an operative fraudulent enterprise. It's an operative conspiratorial.
Is it enough? Is it enough if they held the hearing without his brother being there?
Well, you have a right to due process, okay? And with an issue about if it was related to civil commitment or liberty, you'd have what's called intermediate scrutiny. So you have a high level of scrutiny on the case. So that's an issue. But you also always have a due process right if there's an issue that relates to you. And the question becomes, though, is the brother properly before the court? Is the brother petitioning the court? That's the whole thing. He's a party in interest, but he wasn't that's interested, but he's not a necessary party at that point. There's a big difference here. So that's the problem is that there's so many legal loopholes, so many legal pitfalls that you can go down that the judge doesn't have to entertain this unless it's a clear, as day type thing. The problem I saw with this is the judge didn't give you the opportunity to be heard, the opportunity to make your case that you should be able to be an intervener. But that being said, the intervener standard is high because it has to be clearly material. Like an intervening party is a perfect example is, let's say someone is trying to claim something about a property. So Mike Volpe is suing Rich Luthmann because Rich Luthmann has a Michael Jordan signed championship trophy or something like that he owns, and Michael Volpe says, that's my trophy, I bought it for Rich Luthmann. Jackie could come in the case and say, I'm an intervening party here because it's affecting my right to have that Michael Jordan trophy because I am the actual owner. Here's my bill of sale. Here's my certificate of authenticity. Luthmann shouldn't even have it. Volpe says he bought it, but he was in no position to buy it. I'm the intervening party. The court should take me right away because I have stuff that bear upon the final resolution of the case. That has to be so material to the case that the court lets the other party. That being said, Jackie, if she's going after the trophy, she would say, may want to file her own lawsuit where she's the plaintiff against both of us and join the cases because of the judicial economy involved. That's where you get the respect. When you come in not as the party that's a plaintiff or a defendant, you're treated like a redheaded stepchild in the court. You don't have the full panoply of rights under the federal rules. So
so Judge Wood didn't do anything wrong, it sounds like, in your opinion.
She didn't do anything helpful, right? She didn't do anything helpful. But but she did do something wrong. I don't think she gave a full opportunity to be heard, and I don't think she gave a full ability to create a record because you always have a right to appeal. And if you want to appeal something, you want to be able to make a record. She should have come there and asked you. And I think you went in pro se. She should have went in and asked you why you believe you have a right to intervene. What's the material?
Hold on. Judge Wood wouldn't do it. Roy, why do you think you have a right to intervene in Jackie's federal case?
Can I say he did actually ask for something?
Well,
Roy, go ahead, and then Jackie.
Just want to say this immediately. The judge did this. She was in the process of collecting information about what my complaint was, and then became the jury and said, no, that won't work.
No. But before, why do you think you should intervene in Jackie's federal case?
Well, because I want to pin the judge's actions in both of our cases are the same. Why not?
Yeah,
that sounds like a problem.
That's the problem. I think that she heard when you said that something that smacks of judicial immunity. You were complaining about what's inside the four corners of the document and her decision and her activities as a judge. In order to say that this judge is corrupt, you have to show something more than that. You have to show some type of violation of their oath of office, some type of dishonesty, some type of collusion, conspiracy, the fact that no matter what was said in front of her, she was going to rule a certain way, or he was going to rule a certain way. That's the type of thing that you have to show. And you have to show it outside the four. I think that's what the judge heard from you. She kept on saying, she heard it in layman's terms, I don't like what this judge said, so he must be corrupt. And that's both squarely in judicial. I think that's what happened. I think this is a misunderstanding, and I would have liked the judge to have made the record for you, allow you to make the record on the record what you believe happened. Because the second you say he ruled this way on this case and he ruled this way in that case, that is judicial immunity. He ruled this way in this case, he ruled this way in that case, because he's engaged in a pattern of corruption outside the office. And here's the reasons why, and here's the benefits he's getting, and here's the cases that he's thrown. That's a different story.
So he said this exactly to the judge. He said that Judge Orell put my brother in an unlawful guardianship in 2022. And in 2023, he attempted to put Jackie Sample into an unlawful guardianship, doing the same thing. So he actually used those words at one point.
Is that enough, Rich?
You have to be very, very clear in the sense that if your claim is that he's using guardianship as a corrupt tool, you have to explain how the guardianship, which is legitimate proceeding, is being used corruptly. You have to go, if you're claiming corruption, you have to do a lot of work there to explain the full basis of the corruption. There's something under the rules of Rule 8 and Rule 9 that talks about very specified pleading standards. So when you're talking about a conspiracy, you're talking about fraud in federal court, you have to spell it out like an 8-year-old can understand it. You have to be very, very clear as you can't say, this is corrupt. The rulings are this. Look what he does. He does this all the time. Well, of course he does it all the time. He's a judge. He makes decisions all the time. The judicial immunity is so broad, you have to have something that's like a laser-focused pierce of the judicial immunity, giving specific facts, dates and times, things that he's done. That's the standard here. They protect the judges under the law.
Right. I think you guys probably didn't have enough for federal court. You guys want to add anything?
Well, with the motions, we did a little research and put in some law codes. Of course, we don't know them by heart, but they are included in the complaint. And, we've had a little help here and there with some of this stuff from people that are, more versed in the law. Although we're pro se, we had some outside help. So the law codes and, case laws are included in the complaint. But of course, we're not practicing attorneys.
Okay, let me say this, Michael. There is a fundamental flaw in the way things are conducted, from the court appearances through to evidence presentation, a whole list of things that are all set up in the good boy, the good old boy and the good old girl attitude. And that's why we're in this kind of situation right now.
And then, the common thing is we both have complaints about there's some a pattern of corruption happening in DuPage County Courthouse with multiple judges. It's like a pattern of due process.
Well, what evidence did you present of a pattern of corruption?
So I can speak my complaint specifically. Not one judge would enforce a court order in 2.5 years. They accepted fraudulent financial affidavits. According to our income, I have proof of all of this. I've submitted this stuff.
I think that Rich, am I wrong? But the judges would be immune from that kind of a complaint.
Judges are immune, very, very blatantly immune. That's like the highest, one of the highest levels of, maybe presidential immunity is higher, but judges are pretty immune to everything unless you can show. Like if you catch a judge on camera taking a bribe, and then you show that the case went a certain way, they're not immune. The feds can come and take them right back. But you need to detail. Right? If you're telling me that these people, this judge has a pattern and practice of behavior that's bad, that's fraudulent, it can't just be bad. It can't be something you dislike. It has to rise to the level of fraud, malfeasance, of the office. You need to do something like that in order to have a valid claim that the court's going to entertain to get yourself in the ticket into the ballgame.
He
In my
he had
case,
a pattern of bias for sure, but you're right. Besides that, I don't think it's enough to pierce judicial immunity, which is very
There's,
so
there's
in
no,
my,
there's no crime for being a scumbag. You know,
right.
there are a lot of
Right.
judges out there that are total
Hold
scumbags.
on, Roy. You wanted to add something. Go ahead, Roy. Did you
Oh,
get?
well, the real problem is that it's systemic. And why we're having this problem now is because of the setup that the attorneys and the judges have set up for their empowerment. They, those in power want to retain the power, so they make all these little requirements that you can't jump over and stand on your head.
so let me just say, in my case, there is a clear pattern of colluding, a clear pattern of all four judges accepted fraudulent financial affidavits, right?
It's not enough to pierce
Well,
judicial immunity.
so if a judge is not acting within the Constitution, upholding the Constitution,
The judge in Stump versus Sparkman wasn't even close to acting in the Constitution. They gave him judicial immunity with that particular court case. Judicial immunity is a
so I can
lot
just
stronger
my
than you
case.
think it is.
Judge Arrell was forced to retire.
Right.
Judges aren't forced to retire if they are
Well, he's
acting
acting
appropriately.
unethically. It doesn't mean that you can overcome his judicial immunity. I think you probably didn't have enough. I think Judge Wood was dismissive of you guys, which is the way judges are with pro se litigants, but I don't know if she ruled poorly. But that doesn't excuse anything that Arrell did in both your guys' cases.
So I could just say in my case for certain, the judges are not covered by immunity with their actions. In my particular case,
Harold Stump gave an order to a woman to have her daughter sterilized from his judicial chamber. No hearing. The daughter didn't even know that this order was in place. And then her mother took the daughter to a hospital and told her her tonsils were going to be taken out. And in reality, she was not going to be able to ever get pregnant. And Judge Stump got judicial immunity by the United States Supreme Court. I don't think yours is as bad as what happened with Judge Stump, but he had judicial immunity.
Yeah, so I hear you, but according to the law, what is it, US 42, 1983, my lawsuit is based upon federal law codes, which my lawsuit fits under there. So I'm not, I don't know the codes by heart, but I know for a fact that my lawsuit fits under these law codes, which is why I filed my federal complaint. So these judges are not covered under immunity in my particular lawsuit. I can state that 100% for a fact. According to federal laws, this is not an opinion or feeling.
Rich, you want to add anything, and then we'll let him get the final word, and then we'll wrap up.
I think that you have something. If you can detail it, I would tell you to go to see Ken Gerard's pleadings. I tell you to see we've covered others as well. With Manny Gomez, the private investigator, was helping with the case in Westchester against Ice and Press and others. If you're going to go after judges, it's being done with RICO type cases. Rabbi Belinsky filed one. His is a pretty good test. Look at those cases. See how those things are, because it has to survive the motion to dismiss. So if you're going to claim that a judge did something, okay, you need to be very, very specific on what they did and make sure that it's something that they're not immune for, because judicial immunity
and my lawsuit does have that. There's no motion to dismiss based upon my lawsuit. There was a mention of a lawsuit. I'm sorry, there was a mention of a motion to dismiss because of improper filing. So we got past that. Now there's a mention of motion to dismiss, just asking for a more definitive motion. So my lawsuit actually meets those requirements. I'm 100%.
We'll see. She hasn't dismissed the lawsuit, but she did dismiss Roy's intervening. Roy, did you want to add anything? And then we'll wrap this up.
Well, really, the whole system is rotten to the core. Because there should be no singular judge. It should be handled by three people who are less likely to confer and get into criminal acts. But that's what's happening, including the president of the United States. We have a singular president who does whatever he pleases. And
all right, you are proposing a committee of judges along with a committee of presidents.
You can change that, Michael. Let me know.
All right, guys. Thank you for being here. We'll be back next week.